So what is the Maryland Insurance Administration, or the MIA? We are an independent state agency that regulates Maryland's insurance industry, and that includes related entities such as HMOs, private review agents, TPAs, et cetera. The MIA implements and enforces laws enacted by the General Assembly that affect Maryland's insurance industry. And the MIA protects consumers and investigates and resolves complaints about insurers and insurance agents or producers that conduct business in Maryland. And the MIA investigates acts of insurance fraud. So here we're focusing on provider credentialing, and Section 15.112 of the insurance article is the primary law on provider panels, and it establishes the minimum requirements for provider credentialing in Maryland. And it applies to carriers, and there is a definition of carriers specific to this law. And carriers include insurers, health maintenance organizations, nonprofit health service plans, dental plan organizations, and any other person that provides health benefit plans subject to regulation by the state, and also an entity that arranges a provider panel for a carrier. And so that kind of entity, I think right now the best known one I've seen is probably MultiPlan. Over the years, I've seen other entities where their business is to put together provider panels, and then they contract with carriers or self-funded plans in order to offer a provider network to people with a health plan. So who is covered by the law in terms of providers? So Section 15.112 defines provider to mean a healthcare practitioner or group of healthcare practitioners who are licensed, certified, or otherwise authorized by law to provide healthcare services. And then Section 15.112G gives the requirements for the application process used by carriers to process an application by a provider, which means a practitioner, to participate on the carrier's provider panel. So there is a uniform credentialing form. This is specified by 15.112.1 that a carrier must accept the uniform credentialing form as the sole application. And the MIA has designated the CAQH form as the uniform credentialing form. So that is the form that all carriers must accept. A carrier is required to provide an application to a provider on request. If a carrier receives an incomplete application, the carrier must send notice within 10 days to indicate what additional information is needed. When a complete application is received, the carrier has 30 days to send the provider written notice of its intent to continue the process or to reject the provider. If the carrier proceeds with credentialing, it has 120 days from the date of the notice to accept or reject the provider for participation and to send written notice. So the total time frame for an application that goes through the entire process is 150 days, or up to 150 days, because the 120 days runs from the date of the notice. Now, a carrier may deny credentialing based on a full provider panel, but prohibited reasons for denials include, and also prohibited reasons for terminating providers include gender, race, age, religion, national origin, or protected category under the Americans with Disabilities Act. And this part is important. It includes the number or types of appeals based on medical necessity filed by the provider, and appeals or complaints through an internal review process established by the carrier for that purpose. And also, a carrier may not limit the number of behavioral health providers at a healthcare facility that may be credentialed. I want to highlight again, when I'm out and about, I hear a lot of providers who say that they're afraid to file appeals or complaints with the MIA due to retaliation or having their contracts terminated. That is prohibited, and I have not seen any complaints about termination for that reason. However, it does specify that it is based on appeals for medical necessity and appeals or complaints through the established internal review process. So complaints that do not follow that process, that would be could be a problem and a basis for termination. Again, a carrier is permitted to deny participation when you apply if they have enough providers on the panel already and for any other reason that is not prohibited. If you're already on a panel, the carrier may terminate participation due to already having a full panel or any reason that is not prohibited if they give at least 90 days written notice, or immediately upon notice if the termination is due to fraud, patient abuse, incompetence, or loss of licensure status. So that covers many of the initial application questions. Now, if a group practice hires a provider who is not credentialed, that is also addressed by the law. And so the carrier is required to reimburse the participating group practice at its participating provider rates for a provider who is not participating if the provider is employed by or a member of the group practice, has applied for credentialing, and the carrier intends to continue to process the application, has a valid license to practice in the state, and is currently credentialed by an accredited hospital, or has professional liability insurance. Okay, if you're already credentialed and you change employers, and this applies if a provider changes a federal tax ID number, if the provider's employer changes a federal tax ID number, or if the provider changes to a new employer and the new employer participates on the carrier's provider panel, or is the employer of providers that participate on the carrier's provider panel. And so, as a provider, you are required to give notice, and the notice must be in writing at least 45 days before the effective date of the change. Usually, your current provider contract will have the address to send notice to the carrier. And the notice must include a statement of intent to continue to provide services in the same field of specialization, the effective date of the change in tax ID numbers, the new federal tax ID number and a copy of the Form W-9, the new employer's name, the employer's contact person, and the address, telephone number, fax number, and email address for the contact person. And then the carrier has 30 business days to acknowledge receipt, and if the carrier deems necessary, to issue a new provider number. Again, note that that is working days. Okay, if you participate at some locations and not at other locations. If the provider participates through a group practice or healthcare facility, the carrier may not require the provider to be considered participating when providing services to a carrier's enrollee through an individual or group practice that does not have a contract with the carrier, and when billing for the services using a different federal tax ID number than that used by the participating group or healthcare facility. And the provider must notify the enrollee that the provider is not participating and what the anticipated total charges are. Provider directory updates, and this is something we hear a great deal about. Carriers are required to have accurate and up-to-date directories. And so if you have a change in your address or other contact information, or if you are no longer accepting new patients, you should contact the provider and update that immediately, as soon as you can. And if you want to terminate your provider contract, you need to give at least 90 days notice. And that is a requirement in statute. Facilities. As we talked about, the definition of a provider is for practitioners. And so that means a facility does not fall into the current definition. And so usually a facility is credentialed to provide facility services. And then practitioners are credentialed and billed separately. For example, a hospital may be participating for emergency room facility services, but the physicians in the emergency room may or may not participate and will bill separately. And then here is our contact information. So as you see, we have some notes. The first question I see is this training specific for health insurance carriers? Yes, it is. This is in Title 15 of the insurance article, which applies to health insurance. The next question, I'm not quite sure what it's asking. If a new provider is not credentialed, is that for HMO panels only for reimbursement? This law applies to all provider panels for health insurance. And that can include an entity that has a contract with HMOs or insurance carriers. So things are not limited only to HMOs. And we have a question about the MIAA's proposed legislation. That is not something I'm prepared to answer right now. That is probably best addressed to our government relations department. I have a question about changing an employer while establishing a private practice, and that may be something that if you can email me with more information, I can probably address it better then. And then I have a question about a temporary provider in a facility through an agency. That may be an issue if you're credentialed as a facility and a provider is acting as an employee and your employees are not usually credentialed separately. I don't think that would be a problem. But if you have more details to provide, I'd be happy to consider that in an email. And we are getting about questions about whether this will be emailed. We will be posting this on our website. Okay, I see. My email address is Mary, M-A-R-Y, .quay@maryland.gov. We also have a general complaints email box at lhcomplaints.mia@maryland.gov. And questions can be sent to either of those. Okay, so now I'm getting a question about the NHMO may not deny a provider solely because the provider was not participating at the time of service. This is a little bit different from what we're covering as credentialing. HMOs have a pretty complex set of laws regarding when they have to pay a provider who is not currently a member of the panel. That goes into what is defined as a covered service in 19701 of the Health General article. And it will include emergency services. It will include if you're referred to a non-participating provider by a participating provider. It will include out-of-area urgent care services. And it may include if you go to in some circumstances, when you see a provider where the group is participating, but the individual is not. So the part of 15.112 that addresses this is general to all types of providers. HMOs have a separate regulatory framework. I did not get into I have a question about the paneling of licensed master social workers and licensed graduate professional counselors, if I recall what those letters stand for properly. And yes, there is a subsection of the law that took effect late last year that specifically addresses adding those types of providers to the panel. I did not get into it today. It depends on the type of practice they are joining. And that is something that we can address separately. It is something that is recent in the law, but it is in that law. And I have a question about the definition of provider and whether I only mean practitioner or physician and not facilities. I am, in general, using the term as it is defined in the statute. And so if I copied or used statutory language, it would refer to practitioners and not facilities. I have a question about are providers who completed their residencies considered psychiatrists, or do they have to be board certified? And that would be a credentialing standard. I think that many carriers would be able to decide. I have generally seen the phrase board certified or board eligible, but you should contact the specific carrier. I have a question regarding mental health providers. It does not give a full citation, so it's a little hard to tell what's going on. You know, carriers are allowed to close their panels, and some carriers have a business model that is focused on a very narrow network, which means that they will have smaller panels than other carriers. We do have network adequacy laws, but that's a separate law from the credentialing law. And then can you speak to the MIA regarding a complaint? We give our phone number. If you have filed a complaint, then you may contact the specific investigator. Okay, I have a question about MCOs and self-referred services. MCOs are an entity that participate in the Medicaid program through the Health Choice program, and we do not regulate them to that level. We regulate them for solvency primarily. And so those questions should be addressed to the Department of Health. Looks like we may have had connection issues for a moment, but we're looking to see if there are any more questions. Okay, I have a question about an incomplete application. It says a notice must be sent within 10 days. I believe that is calendar days, but typically it is written, and it would depend. The question goes on to, can the notice be emailed or what formats are acceptable? Typically, if the provider has agreed to emailed or electronic communications, that would be acceptable. And it looks like we're having some connection issues again. Okay, let's see. Okay, I have a question. Is re-credentialing the same as credentialing a new provider in terms of time frames? And that goes back to a couple of, let me see, I'm looking for it, because that would go to the slides about if a credentialed provider changes employers or tax ID numbers. Generally, re-credentialing is not permitted. If it's renewal of credentialing, that could be the same time frames as credentialing. And yes, we are just doing Q&A now. I have a question about the uniform application, and yes, carriers are required to accept the CAQH as the sole application. I would have to look if any alternative is permitted if a provider chooses not to use CAQH. But that is the uniform credentialing form, and it is required to be accepted. I have a question about if a provider is not paneled with a specific carrier. There are very specific instances when the insurance company has to pay. Typically, that applies to an HMO in specific circumstances. It also applies if a provider joins a group practice that is participating on the panel. Okay, I have a question about TRICARE not accepting CAQH. TRICARE is a federal government program, so that would not fit within the definition of a carrier. And so they would not be subject to the Maryland state law. We have a question about the CAQH and whether insurance companies can require their own application. And the law is that they need to accept the CAQH as the sole credentialing form. That is the uniform form established by the state. And if you have complaints about specific carriers that are requiring an additional form, it would be helpful if you file that as a complaint so that we can gather more information about whether it's a state-regulated plan. And that would give us the opportunity to find out what is going on. And if indeed it is a violation, then we can take action based on that. I have a question about the Maryland Uniform Credentialing application. That was used quite some time ago at this point. And it is a form that we developed, and then subsequently we went to CAQH as the uniform credentialing form. And so, again, if you're getting requests from carriers to use additional credentialing forms, that is something that you can file as a complaint with us, and we can make sure it's a regulated plan that meets the definition of carrier and find out exactly what they're doing and take action if they are using forms that they should not be using. Okay, I got a question about Maryland Medicaid, and again, Medicaid does not fit into the category of carrier, does not meet the definition, so Medicaid can do things a bit differently. Although I believe Medicaid does make the law applicable through their own regulations, but I do not know details of that off the top of my head. And they may not use the uniform credentialing form. Okay, I have a question about Medicare, and yes, Medicare is a federal program that is not subject to state law. And following up on the Maryland Uniform Credentialing Form, now we've switched to using the CAQH as the Uniform Credentialing Form in Maryland. I have a question about credentialing log, and that is something that I would need to look into. Again, my email address is mary.quay, Kwei, @maryland.gov. This webinar, yes, applies only to private insurance and entities that meet the definition of carrier, because that is what we can regulate here. I'm asked for a list of private insurance companies, and that would be hundreds of companies long. So you can look at our website. We have a company search function there, and you can find any insurance companies that you're looking for. I have a question about updates to information. That's something I do not know off the top of my head. I would have to double check that. This was intended as a basics of credentialing, so that is something I would have to double check. I have a question about Johns Hopkins and whether it's whether Johns Hopkins is considered a carrier. So my understanding is Johns Hopkins has several types of health plans, but I don't believe any of them counts as a carrier. If they have a plan that develops provider panels that they then in turn have a contract with an insurance company for, that would make that panel would be considered a carrier. But if it is solely for their self-funded business or for their MCO or their Medicare Advantage plan, then that does not fall within the definition of a carrier. I think the question about the credentialing log is probably a market conduct issue of what they are looking for. Certainly in complaints, we would be looking for a timeline, but I have to find out about the log. I am not seeing any more questions, so we'll give it another minute or two, and if there are no more questions, we will wrap up. Okay, so I have a question about insurance that does not fall under the definition of a carrier and whether they have to panel licensed graduate professional counselors. No, they would not be subject to the law. If they're not subject to state regulation, then state law would not apply. And that would include self-funded plans, federal plans, and some other entities. I have a question. Can you provide the website for the provider panels? I'm not quite sure what that's asking. Every carrier will have a website with their provider directory online. And then the CAQH would make available the uniform credentialing form. Okay, so this recording and the PowerPoint deck will be available on the webinar section of our website today or tomorrow. Okay, I now have a question. It's asking for the website with the law for provider panels. And that would be the General Assembly's website, has all the statutes for the state of Maryland. And I believe it is MGA.leg.maryland.gov. I'm not positive off the top of my head, but it is the Maryland General Assembly's website, and there is an insurance statutes tab. Okay, we have posted the web address for the General Assembly's website, and then they have a tab for statutes, and that's under the insurance article. There may be other private sources for Maryland insurance law. Okay, I have a question about a group contract with a carrier. And yes, if a new provider meets the qualifications in the statute, a new provider joining a participating group practice should be paid as participating while the credentialing process is going through its course. And we're not, oh, I see one more. Okay, so another question, is this the case if the contract is not for the facility with the insurance? So if facilities can be a little bit different where they have employees who are billing through the facility, and the facility bills for services separate from physicians who may also provide services there. And then there is also a group practice where a new provider is joining the already credentialed group practice. If the group practice does not have a contract with the carrier and is not on the provider panel, then no, a new provider would not be treated as participating if they're not separately credentialed. Okay, so the question is, if there's a group contractor, does the provider still need to be individually contracted to get paid? Ultimately, it will depend on the terms of your provider contract as a group practice. However, in most cases, it will be the situation that the new provider will have to apply to be credentialed separately, but while they're going through that process, they would still be paid as part of the group practice. But at some point, it is up to your group contract how individuals get credentialed to be covered by the group contract. And the follow-up asks if that means that if they see someone while they're being credentialed before it's complete, does that mean they must pay the claim? And under Maryland law, if Maryland law applies, then yes, if it meets the criteria that it is a group practice and the person is, the provider is being credentialed, then yes. If they were denied and the process is complete and they were denied, then no, they do not have to pay. At least not once the denial goes through. Okay, I have a question about Maryland Medicaid, and that really should be directed to the Department of Health because they may operate a bit differently than we apply this law because it is a state program. Okay, I have a question about why can't all carriers backdate for services while the credentialing is being processed, and I don't know why they don't all do that. Our role is to enforce the law, and so there's that specific circumstance we discussed where they have to pay, but if it's simply an individual provider waiting for credentialing, that may not apply. I have a question about are behavioral health payers handled the same as commercial payers? And that will depend on whether they meet the definition of a carrier. So for example, Magellan was quite active in the market for a while. And if you had a contract with Magellan, that might be an entity that arranges provider panels for insurance companies and other carriers. And so in that sense, the law would apply to them. If it's a behavioral health payer that only contracts with, say, the military or Medicare or Medicaid or self-funded plans, that would be different because they don't fall within a category of carrier as defined. But if it is a behavioral health payer that has a contract with HMOs or insurance companies, then it would fall under the law. Okay, I had a request to share the slide of a definition of a carrier. And so I have brought up that slide. Okay, I'm not seeing any more questions. We'll give it another minute. Okay. Uh, so, yes, to reiterate, behavioral health payers may be carriers that are entities that arrange a provider panel for a carrier. If the behavioral health payer has a contract with an insurance company, HMO, et cetera, and it's a plan regulated by the state, then yes, the law would apply to the behavioral health payer. If they only arrange provider panels for self-funded or federal plans, then it would not. But if it is an entity that arranges provider panels, then the law applies. Okay, I have a question about if a list of carriers is on our website. We do have a company search function. There are hundreds of entities that might be considered carriers depending on the products they offer. Just because an entity is licensed as a health insurer may not mean that they offer all health benefit plans or have provider panels. And we aren't always sure what they are. And we also do not require these other entities that arrange provider panels to register with us. So we aren't always sure who they are. We regulate the primary carriers directly. Okay, so I have a question about if a company, how do you know if a company is a carrier? You can, if they are unable to tell you with whom they have a contract, typically you can check our website, the Insurance Administration's website for insurance companies to see if they tell you whom they arrange panels for. You can verify that. And I have a follow-up on, well, I guess it's from a different person about Optum and Beacon. It looks like it's about the state MCO plan. Again, Medicaid is separate. I know Optum does arrange panels perhaps for some of the insurers as well. So if Optum is a behavioral health company, if they arrange panels that they then contract with insurance companies or HMOs for, then they are considered a carrier, but for Medicaid, they would not be. Medicaid may have its own requirements. I'm not seeing any more questions. I'll give it another minute or two. Okay, well, thank you everyone for participating. We do have almost noon and I'm out of questions, so we will be posting this as we said, and you can check it out on our website under webinars in the next day or two. Thank you.